and the Ministry of Health of Argentina, and I want to thank them for helping us organize this event. I also serve as the director for the Center for Transformational Health Law at the O'Neill Institute at Georgetown University. And we're gathered today to present sort of a series of global leaders and people who are really experienced and accomplished in a field of the law that has raised a lot of questions and has become an important issue over the course of infectious disease response and pandemic response, especially COVID-19. And that is the sort of the concept of liability and risk management. At its heart, it has to do with the risks that accompany the use of interventions, particularly novel interventions like newly developed vaccines, and who should be responsible for rare severe adverse events. There are some other risks that end up being part of that conversation that one of our distinguished speakers will address. It is not a new issue in international law or treaty making. It has been addressed in the environmental context. It's been addressed in the public health context. So it isn't new, but in the course of the emerging pandemic accord, it's raised a lot of questions. And we believe very firmly that it is one of those issues that can be addressed in advance of a pandemic, and done so in order to shorten the time in which necessary interventions can help address human suffering and respond to pandemics when they emerge. So that is our agenda for today. You should all have a copy of the agenda. We're going to address specific perspectives on liability and risk management from the perspective of financiers or donors, from the perspective of international organizations that facilitate the development and shipment of interventions, and those who have served in government looking at these issues as well. So with that, I'm going to go ahead and turn it over to our initial speaker, Professor John Monahan. He's the senior advisor to the president of Georgetown University for Global Health. He is also a professor of medicine and a professor of law, and has really a distinguished record and a lot of experience that's relevant. And he's going to spend some time outlining in broad scope the issues that have faced the global community in liability and risk management in the past, and those that face us today as the pandemic accord emerges. So thanks so much, John.
Thanks a lot. Thank you, Sam, for the kind introduction. Sorry, I was just had a slight technical difficulty here, but well, first off, thank you, everybody, and thank you for the opportunity to share some reflections on the importance of liability risk management as a key element of legal preparedness for future global health emergencies. I just say I learned about this issue firsthand from firsthand experience. During the early days of the Obama administration, I was asked to take the lead of what is now the Office of Global Affairs at HHS, Department of Health and Human Services, and to work closely with WHO's leadership and other global partners in responding to that pandemic. What I didn't expect, to be candid at that time, was how much time and energy I spent, along with so many public health colleagues in the United States and in other countries, in addressing liability and legal issues in the global rollout of vaccines. It seemed to me at that time, and it still does today, that these issues are better addressed in advance and not in a crisis. The cost of time for public health leaders is too high, and the risk of delay in delivering countermeasures is also too high. So, Kat, if I could ask you to put the next slide up. As Sam indicated, I'm going to attempt to do three things this morning. First, I'll try to describe the basic challenge of liability risk management that will almost certainly arise in future international health emergencies, including a brief review of several technical terms that are commonly used, and that might be hopefully useful to all of you on this call. Second, I'll suggest several reasons why, at least I think it is better to act now to address liability issues before the next pandemic or similar event. And then third, I'll try to point you to some resources being developed by the Global Health Security Agenda and others that may be of use to countries and international organizations considering this matter in the INB or in other forums. So Kat, if you could go to the next slide. Let me start then with the first, which try to define the issue that we've got before us. The issue of liability is a legal challenge that will almost certainly arise in any future public health emergency, especially during a pandemic. And I should say, I realize that this is an issue that raises strongly held views on all sides, and I have my own as well. But this morning, I'm going to try and present the scenario that seems, to me at least, the most likely to occur given our past experience and think about issues from that perspective. So with that, my view is that so long as private companies can be expected to play uh, uh, to develop or manufacture some or all of the vaccines or other countermeasures in the next pandemic or health emergency, and that seems almost certainly the case. Those companies will seek to manage liability risks related to adverse events that could be associated with their vaccines or other countermeasures they produce. As in COVID, vaccines and other health products required to address the next pandemic or another emergency will need to be developed rapidly and will likely have emergency authorization for their use for at least a period of time before receiving full licensure. Despite rigorous testing for emergency use, as with the COVID vaccines, the introduction of products at mass scale always carries some risk of rare or unforeseen events. So for some period of time while countermeasures are in use, it can be reasonably anticipated companies will be unable to secure insurance for such risks and will be reluctant to self-insure. Why does this matter? Under most countries' laws, a manufacturer of a product faces responsibility for adverse events associated with the anticipated use of its product, even in emergencies, unless alternate provisions are made in relevant statutes or legal processes. So based on experience from COVID and H1N1 and Ebola, we can reasonably anticipate that companies are highly likely to request protection from governments and international organizations to help manage the financial risk of potential legal claims related to adverse events, including the legal expenses incurred in defending those cases. So in previous emergencies, we know the negotiations between manufacturers and countries or international entities have proven complex and time-consuming for all the parties, especially in a context when time is often of the essence. This has the potential of delaying deployment of countermeasures. Now, of course, different countries have taken different approaches to this challenge, often in the context of negotiating contracts for the purchase and delivery of vaccines. Some countries, such as the United States, provide immunity to manufacturers in most circumstances and have created a no-fault compensation program. Other countries have offered indemnification to manufacturers for damages resulting from legal claims. Some, but not all, of countries offering indemnification have established some kind of no-fault or comparable system. So, and importantly, in the context of COVID, WHO took the lead in developing the first ever compensation mechanism for low-income countries, which is, again, so that it's a complicated landscape. So, and I realize a lot of this, for those of you, may sound like a lot of legalese out there. So I thought maybe I'd try to take some of the terms I just referenced and define them. So Kat, if I could ask you to move the next, thank you. Sorry for the print, but hopefully it's readable for each of you. So given this legalese, I thought maybe we could walk through some of the key terms, at least as I see it. First is liability risk management. This is the process of managing the risk of parties being held responsible for certain types of losses. In this case, we are focusing on financial losses rendered by legal judgments associated with adverse events to countermeasures, such as vaccines. In a health emergency, this typically involves allocating risk between the manufacturers and governments procuring such countermeasures from those manufacturers. The second concept I want to talk about is immunity. Some countries, as I noted, protect manufacturers from financial risk associated with adverse events during health emergencies by providing immunity in legal proceedings in almost all cases. With immunity, the companies may move to dismiss claims brought against them without ever having to go to trial or have any significant proceedings on the facts. This reduces the company's exposure to judgments and, of course, minimizes their legal expenses. Let me contrast that with the third concept, which is indemnification. This is a legal concept in which one party commits to compensate another party for any prospective or future loss or damage. In the context of the COVID-19 pandemic, clauses in vaccine purchase contracts establish financial indemnification, often by national governments, in this case, the indemnifying party, to cover financial losses potentially incurred by the vaccine manufacturers, in that case, the indemnified party, as a result or associated with adverse event lawsuits. And so the final concept, and this focuses less on the relationship to the manufacturer and more on individuals, is no-fault compensation. Some countries have established no-fault compensation schemes, which seek to compensate individuals who experience serious vaccine-related harm or harm related to other countermeasures without requiring those people to prove fault against any individual or entity. Proving fault can be difficult to show. Therefore, injured parties or the legal representatives do not have to prove negligence or fault by the vaccine provider or the health system or the manufacturer before receiving some compensation. These systems are typically operated through administrative processes and do not require claimants to go to court. So putting these concepts together and what I mentioned before, it's clear that many, but not all countries develop explicit strategies for liability risk management. Some countries provide immunity, others offer indemnification. Of those countries, some provide no-fault compensation or access to other types of legal remedies for individuals experiencing adverse events. Some do not. Of course, not having a strategy is a policy decision in its own right, and many countries end up addressing these issues in the context of negotiations. So I hope this gives you at least an introduction to some of the basic terms and how they interplay in the context of a pandemic. So I could ask Kat if you could move to the next slide. So I thought I'd just point out 4 reasons, at least to me, why I think it's better to address liability issues before the next public health emergency rather than in the context of it. First, this can save precious time during health emergencies. Unlike many public health decisions in the context of an emergency response, which will ultimately depend on our evolving scientific understanding of the nature of a novel or re-emerging pathogen, and/or will depend on the efficacy of potential public health interventions, virtually all the legal issues that I've identified and are predictable. And I think, and at least as a result, are at least potentially resolvable in advance, or at least some are. And so time matters. Second, a pandemic or other emergency is simply not the best time for countries to draft new laws addressing inadequacies of their public health authorities, or for parties to negotiate well-crafted solutions to complex problems like liability risk management. Frankly, time spent by public health officials on liability issues during a health emergency can sometimes come at the expense of time that could be used for planning or implementing public health responses. Time spent negotiating the terms of liability risks slowing the deployment of countermeasures that may save lives. So that's the second thought. And then the third I wanted to focus on is waiting to address these issues until the next pandemic is not going to make things any easier. The complex issues will not be any simpler to resolve in the heat of a crisis, and the practical reality is that the companies which produce countermeasures, the countries with which those manufacturers have contracts, and the jurisdictions within which the countermeasures are produced and stored will almost certainly have substantial leverage in addressing liability risk management in the next crisis. As a practical matter, the capability to develop and manufacture vaccines on a global scale largely, though not exclusively, sits with pharmaceutical companies. There's simply no reason to wait on these issues. And then fourth, preparing in advance to address the likely demands of manufacturers for protections against loss may help reduce the risk of inequity in a future emergency. This issue has been seen to limit access to countermeasures, particularly for lower middle income countries, and especially in contexts where they may be negotiating for health products in a competitive environment. So let me turn to the last thought. So those are the 4 reasons I think we should act now. And then, Kat, if I could ask you to move to the next slide. And finally, I'd like to share with you some resources that may be useful in developing country-level and global solutions to liability issues, including those of you who are deeply engaged in the IMB and the Working Group on IHRs. As a starting point, we owe an enormous debt to WHO, CEPI, Gavi, UNICEF, the World Economic Forum, and others, at least in my judgment, who've continued to work tirelessly on these issues over the years and have addressed them in the variety of very high stress, high intensity contexts. In particular, I want to note the work at work again at WHO in setting up the first global no-fault compensation system as part of COVAX. And you'll hear after me from Sharmila Ramaswamy about strategies that the World Bank has taken to support countries in managing these risks. You'll hear from Dick Wilder about the innovative approaches taken by COVAX during the COVID pandemic under his exceptional leadership, and from Chanel Hall, who will tell us about the complex needs of migrants who are far too often left out of these discussions going forward. So looking ahead, in my view, the most important step is for countries and global international organizations to consider liability as part of a broader legal preparedness framework for future public health emergencies. Advanced discussions on managing the liability risk of countermeasures while maximizing equitable access can lead, at least potentially, to long-term and more balanced solutions. In this way, these solutions have a better chance of being systematically integrated into countries' legal systems and incentivizing the actions of private sector partners, all in the effort to try to save at least help as many people as possible during the context of an emergency. So in other words, the more these challenges and factors are addressed in legislation, in clauses, in countermeasure procurement contracts, and in legal preparedness plans, the more rapidly vaccines and countermeasures may be available to be distributed and administered in an equitable manner and where they're needed most. So to support this work, the Global Health Security Agenda, which is hosting today's call, brought together a group of experts in February 2022 to establish a working group on liability risk management to generate greater awareness of the issue and to lift up the importance of applying a legal preparedness approach to the liability debate and to help develop technical guidance going forward. Based on this working group's plans, GHSA will be providing guidance in the following areas: draft legislation and comparable legislation from other countries that you can review that may be enacted to facilitate expeditious procurement of medical countermeasures, procurement agreement contractual clauses to provide countries with a starting point in negotiations with manufacturers during an emergency and to promote consistency in contractual terms across countries. Another would be indemnity planning and budgeting materials to be used in the event that funding is required to guarantee a contractual indemnity provision. And then knowledge about no-fault compensation systems that help mitigate the risk of claims by compensating individuals who have experienced or have an experience related to adverse events. So let me summarize by closing before turning to the other exceptional speakers that you have today. Time and again, the world has encountered a series of challenges during international health emergencies in accessing medical countermeasures, in part because we've been unable to rapidly resolve recurring legal issues related to liability. The complexity and time lost in negotiating procurement agreements between countries and manufacturers during COVID-19 could have been mitigated with greater legal preparedness. It seems to me, before the next emergency, it would be wise to work with and support governments and international organizations to help them be as ready as possible to address inevitable issues relating to liability. And so for those of you from governments and international institutions on the Zoom today, we welcome your participation in this process and helping find solutions, because this is ultimately a multidisciplinary, multi-sectoral issue for the community as a whole. So let me close with that, and I'll turn it back to Sam, and thank you for the opportunity.
Thanks so much, John. I want to just make one quick note before turning over to Sharmila. The leadership of the action packages is by the U.S. government, but the U.S. government is represented both by the U.S. Centers for Disease Control and by the Office of Global Affairs. And I apologize for omitting my very good partners and friends. So Sharmila, over to you from the perspective of the World Bank.
Thank you very much, Sam, and thank you to the organizer, to the Global Health Security Agenda team, to O'Neill for inviting me this morning. It's a pleasure to be here. Good morning, good afternoon, good evening to all of you, wherever you may be at the moment. Thank you to John for a fantastic sort of introduction to the topic. That was a really good start to the morning and to the session as a whole. So a bit of an introduction about myself. My name is Shamila Ramasamy. I am a senior counsel here at the World Bank. I'm a capital markets lawyer by training, so it's a bit of an odd segue into what we're discussing today in terms of liability risk management. But what I cover here at the World Bank really does sort of intersect with pandemic financing, and that's how I came to sort of be really involved in these issues here at the World Bank during the pandemic. I work on innovative financing, and I'm also the lead lawyer for the International Development Association, or IDA. And so as part of both of those portfolios, I was really sort of in the thick of things here at the World Bank during our COVID-19 response activities here in Washington, D.C. So it's great to be here again, and thanks again to the organizers for inviting me. So today, what I hope to do in my brief session, and I'm going to try to keep it very brief, and I don't have the excellent slides that John had, I'm afraid, so you'll have to sort of deal with this this base throughout the session. What I'm going to try and cover very briefly is just to give you a perspective of a multilateral financier as we were trying to support our member countries during the thick of things, purchasing of vaccines right at the height of the pandemic. Now, it's a small slot for a big topic, so I'm going to try to be, very brief, and it'll be very condensed, unfortunately, so happy to take questions later or offline. So during the session, I'm going to try and cover just three aspects, touching very briefly, again, on liability risk management in the context of the pandemic. And then secondly, I'll try to sort of share some experiences and observations of the bank as we supported countries in their COVID-19 vaccine purchasing, but also countries that were specifically financed and supported by the bank in those activities. And then lastly, I'll try to touch upon briefly on what we should be thinking about going forward. And with that, a little bit of a caveat, I have not been involved in the WHO discussions on Article 15 that are ongoing. So this is really just a set of observations and a perspective for my experience during the pandemic itself, all through the lens, of course, of equitable access to vaccines, because that's really something that I took away personally from our work at the World Bank during the pandemic. What we experienced really was that, and then this is to give the upshot of my little talk away somewhat, but really the experience that we had was liability risk management issues really did play a very strong role in restricting equitable access to vaccines for lower middle income countries. And so with that, let me try to sort of kick off, firstly, setting the scene for risk allocation. Now, John talked about this in a lot more detail earlier, but just to sort of summarize, risks appear throughout the vaccine process, delivery, distribution, administration, and also after administration. And the key risks include serious adverse effects from the vaccine and allegations of negligent vaccine distribution or manufacturing or design defect claims. And now, no one mechanism can eliminate risk entirely. There are a number of instruments in the toolkit, especially here at the bank as well. There are contractual provisions, indemnification provisions, domestic legislation that countries employ, including the establishment of no-fault compensation mechanisms. And lastly, countries also put in place financial backstops, so funding liability obligations. And all of these can operate to allocate risk more equally amongst participants, both purchasers and sellers. But really what we experienced here at the bank was that the pandemic was an unprecedented event on so many levels for all of us. I'm sure we all experienced this personally. But in the context of the scale and the speed of vaccine research, development, production, and deployment, that's one of the sort of unprecedented elements that really sort of impacted liability risk management as a whole. It created the perfect storm of coupling extreme demand, which outstripped supply at incredible pace. And that really did sort of translate to an ecosystem for borrowers and IBRD and IDA borrowers, but also specifically countries, lower middle income countries, where there was a disruption in the balance of more traditional risk sharing in vaccine procurement and financing. So the key takeaway from our experience really was that at the height of the pandemic, the balance of power was skewed in favor of the private sector and vaccine manufacturers. So not only did countries urgently need vaccines to mitigate their public health crisis, but demand for vaccines far outstripped supply. And this sort of ties into something John was talking about earlier, which is the worst time really to start negotiating and thinking about how to manage liability risk in the context of vaccine production, supply, distribution, administration is during a pandemic, because of this perfect storm where you do have demand for vaccines outstripping supply. So with all that, moving on to the second aspect and second sort of section of my presentation, what was our experience more specifically? So the World Bank during the pandemic was helping developing countries strengthen their pandemic response, increase disease surveillance, and improve public health interventions generally. And what we delivered in the end was an unprecedented $204 billion financial support at the height of the pandemic, of which $135 billion came from IDA and IBRD, and $60 billion from IFC and $9 billion from MEGA. Now, our project supported a range of activities, including most importantly, obviously, the support for countries to purchase or deploy COVID vaccines. But our projects also had components that were far-reaching beyond vaccines, included restructuring, redeployment, and reallocation of existing resources, and a lot of sort of ancillary pandemic response and economic shocks, trying to sort of address some of the economic shocks that countries faced as well. So sort of far-reaching beyond vaccine deployment. So with that lens, what we were able to sort of see is that, we as a multilateral were helpful in some respects in sort of supporting countries' recovery, but we were also able to facilitate risk allocation and liability risk management and somewhat encourage international best practices. And I think you saw earlier from John's summary, the really sort of tough, hard work that WHO, CEPI, Gavi, COVAX, UNICEF, everybody played in actually developing a strategy and framework for liability risk management that our member countries could also deploy during the pandemic. At the World Bank as well, we were assisting member countries in our own way, assisting them with procurement and reviewing arrangements of their procurement activities, providing technical assistance and training on these subjects. Now, what was our client country experience in the end? Fundamentally, the general gist of our client country's experience was that they were caught between a proverbial rock and a hard place for most of the low middle-income countries. The urgency of the situation placed both borrower and MDB lenders like the World Bank in a challenging position, because we were not only needing to negotiate pricing, but we are also needing to consider liability for various risks. And liability and risk management negotiations were complex for borrowing countries in particular, lower middle income countries. What countries had to do was they had to face with two things. They had to grapple with, firstly, different requirements on liability and indemnification provisions from different purchasing mechanisms. Again, remember, during the height of the pandemic, countries had multiple avenues, and particularly lower middle income countries had multiple avenues to access vaccines. That didn't mean that it translated to equitable access to vaccines, unfortunately. But what it did mean was that there were different requirements placed on them to meet with liability and risk requirements and management requirements. So for instance, COVAX, AVAT had a whole set of requirements, bilateral deals, which countries were entering into directly with manufacturers had a whole set of different requirements. And this did sort of create a imbalanced landscape. But it also was a shifting landscape, because what countries faced as well was, once they'd entered into initial contractual terms with manufacturers, sometimes even through purchasing platforms like COVAX, additional requirements were placed on them based on additional due diligence that manufacturers were undertaking in respect of how best to deliver vaccines in the particular climate. So you had different requirements, and then you had shifting landscape of requirements. And so what this meant was countries were having to really react very quickly and nimbly, and through the support of the organizations that John listed out earlier, COVAX, CEPI, AVAT, Gavi, UNICEF, they did manage to respond as best as they could at the height of the pandemic. But again, the height of the pandemic is not the most ideal to try to deal with shifting landscapes and different requirements. So there's a range of country reactions ultimately, and it all really drilled down to different local legislative frameworks already in place. So for example, some jurisdictions had constitutional or legislative restrictions on offering indemnities. And then some other countries were able to adapt very quickly. For example, Colombia, Philippines, Lebanon were able to adopt laws providing immunity to manufacturers, something that John touched upon earlier briefly as well. So some other situations as well, which we found were equally daunting, where manufacturing contracts included financial restrictions, for instance. So countries were required to provide forms of financial backstop, for instance, general liability insurance. But what is the key takeaway from all of these experiences of countries? The basic principle here is that countries had to get to grips very quickly with the shifting landscape of indemnification and liability issues. And ultimately, this resulted in additional barriers to engagement and delayed access to vaccines, which comes back to the main topic of this event, which is equitable access to vaccines. So I think I'll finish off by saying, one of the main takeaways from the World Bank's experience is that legal preparedness is an important aspect for countries as we now operate in non-pandemic times, to make sure that we build robust systems for risk management and planning before an emergencies. It's essential because it includes building capacity on the ground and assessment of legislative frameworks. These are all necessary due diligence that should be conducted ahead of time, so that we establish strong equitable relationships with third parties well ahead of being caught in the maelstrom and having to deal with them on the go when the balance of when the negotiating balance is way off and skewed. So I'll pause there and say thank you again to everyone for inviting me, and I'll hand back to Sam. Thanks a lot.
Thank you so much, Sharmila. So clearly so far, I think what people might have in mind are populations served by governments to which they're in various ways accountable. Our next speaker will address populations that are stateless, that are often refugees, but nevertheless represent an important population for whom interventions are necessary and maybe even be a priority. So I welcome Chanel Hall, former Assistant Secretary of UNICEF.
Thank you so much. And Sharmila and John, thanks for articulating these complex issues so eloquently and clearly. And I think my brief intervention will just zoom in on maybe an additional challenge or complexity in these negotiations. But first, thanks for the opportunity to share some reflections. I was with UNICEF for 21 years, and most of that time spent or was focused on public health and vaccines. And as a part of that, I spent a lot of years negotiating contracts with the pharmaceutical industry, but also was very involved in humanitarian response. I was a Gavi board member for 8 years, also had some experience with the Global Fund Board. I left UNICEF in 2019 and therefore wasn't there during the pandemic, but I was brought back to help support and advise UNICEF on their efforts and helping populations have equitable access to medical countermeasures. And since then have continued to support in many ways the multilateral system on applying lessons learned and being better prepared for the future. In particular, I support and work with WHO, but I'm an independent contractor, so I'm not speaking for WHO. I really welcome the opportunity to provide some reflections. The current Article 15 language, and of course the whole construct of the INB negotiations, is really about state actors and the responsibilities of state. But there are some populations who either cannot or aren't served by state actors, and these very populations have additional or specific or more vulnerabilities, and include people groups like asylum seekers, refugees, foreign-born migrant workers, stateless persons, internally displaced persons, and even minorities. And the issue of liability, since it's grounded so much in the provision of, or the ability of national governments to indemnify manufacturers, again, when a national government isn't able or willing to do so for these people groups, then these people groups are really left behind. And we could see it firsthand with COVID. We also saw it with monkeypox. And of course, we saw with COVID, there were instruments that were developed to try to mitigate those issues. And obviously the COVAX humanitarian buffer was one of those. And this was a set of doses that were accumulated as a part of the COVAX contracts that would be made available to in situations where governments didn't control an area of their territory, or where national authorities tried to but couldn't reach or couldn't support vaccinations to populations of concern, and just in other cases where national governments otherwise couldn't or wouldn't support certain groups. But the complexity became that who was going to still provide the indemnification? So there were doses that were made available, but they couldn't be shipped or provided to countries because of this issue of who would be assuming liability. And there were obviously very experienced and capable humanitarian actors that were ready to facilitate delivery and uptake of the vaccines, including MSF and many others. And these actors or NGOs were asked to indemnify manufacturers, and which was a financial liability that they could not afford, which meant that the doses couldn't be provided. And this same sort of block occurred when countries had extra doses and wanted to donate those to people in humanitarian crisis in another territory, another state. And they at times were also unable to do so, including because they obviously couldn't provide indemnity for people in other populations in other countries. And there wasn't an intermediary or way of providing those indemnifications. So we have many examples of when that occurred, including, a country in South Asia that wanted to move doses cross-border, but was unable to because of this very, very issue. Similar issues were faced with monkeypox. So more recently with monkeypox, WHO was asked to receive donations and then indemnify manufacturers and take on the liability for products that had only received approval for emergency use. So again, it's not just COVID, but also all of these novel products when there is either a large outbreak or a pandemic, obviously, but an urgent need for a product that hasn't reached its final approval stage, but is at an intermediary stage of approval. WHO has been able to take out insurance for the use of novel products for investigational purposes. So when they're doing, for example, a trial, but the insurance is able to be secured because it's for such a limited number of doses and a narrow scope of use and well-defined scope of use, but they haven't been able to find the solution for broader use of novel products that aren't fully approved. And of course, you know, the heart of the matter is who should assume the risks of liability. The no-fault compensation and insurance provide mechanisms to pay out. But still, even if those exist, and the no-fault compensation that was developed for COVID vaccines was such an important tool, and so novel and innovative, and it was so impressive that was established, but it really is only a partial solution. And if we're not able to address the indemnification issue, then the doses still can't reach populations in need. So if things aren't complicated enough, this is another issue that if we're true to not wanting to leave anyone behind, it's best that we also in advance try to find solutions for these populations that really in many ways are even more vulnerable or also as vulnerable as some of the high-risk populations that are in most need of these novel medical countermeasures. I think the current Article 15 is silent on this issue, and don't know if it's possible for it to be mentioned and therefore to also be included in some of the preparatory work that would then provide solutions in advance or have pre-positioned mechanisms or instruments that could be available. So I think, Shamil, as you described, it's not trying to be negotiated in the heat of the moment when there are such imbalances of power and also so many other things to tackle with that represent much larger numbers of people, and these groups of people that are so vulnerable can more easily even be left behind. So again, thanks for the opportunity to bring this people group to the discussions, and hopefully it helps some reflections on moving forward. So thank you.
Thank you so much. And it's I think it's worth noting sort of in places where we see large stateless movements, refugees, militarized crises, there's a lot of overlap with places where we anticipate infectious disease threats may emerge. So I have in mind the Darien Gap. I have in mind sort of South Asia. So it isn't just, although it's enough for humanitarian instinct to drive us. I think there's also a pragmatic reason we should be thinking and prioritizing in that way. Our next speaker is currently a senior scholar at the O'Neill Institute. He's also a professor from practice at the University of New Hampshire Law School, but led in really critical ways the Coalition for Epidemic Preparedness Innovations participation in the global response over the course of COVID-19. And for that, I want to sort of repeat a thanks I've issued many times, but has a really valuable perspective on some historical cases and ways of thinking about the issue, again, as it takes form in a proposed pandemic accord. So Dick, I'll turn it over to you.
Great, thanks a lot, Sam. Thanks for the kind introduction. And it's a real pleasure to be here. I hope everyone can hear me okay. Sorry, I turned the camera off. And yes, I was general counsel at CEPI, the Coalition for Epidemic Preparedness Innovations, during the COVID-19 pandemic, and was intimately involved in the work in establishing the no-fault compensation mechanism in tandem with the indemnification provisions. And one other person on this call, Anthony Brown, was at that time at Gavi and was one of, I would say, the three people that were sort of on a daily basis engaged in this work at a fairly high level. That was myself and Tony, and then also Anne Mazur from the World Health Organization. And UNICEF was also, very much involved at that time as well, trying to figure out, how in response to the COVID-19 pandemic, we'd be able to address the needs both of the industry that was indicating a requirement for some degree of protection from potential liability, but as well the governments, that were leading the work domestically to vaccinate people and to address, in the many dimensions of the pandemic, and then also the patient population, very importantly, that ensure that they get access to the latest and greatest as quickly as possible of vaccines and other interventions. I think that, John and Sharmila and Chanel have provided a lot of information about this field generally and a bit of history about it. And so I'm going to go through my notes that I made in anticipation of this talk and filter out those things that I think have been adequately covered, and then just focus on what I think would be of interest for this group to get a better understanding historically of how things have evolved, including in the context of a pandemic with COVID-19, to address these issues around potential liability and risk. So I think there's two realities about vaccines that really drive this debate and discussion. One is the fact that vaccines, unlike a host of other interventions, are administered to otherwise healthy people for the most part. Certainly there are vaccines now that are being introduced that are more therapeutic than they are prophylactic. But I think when we think about vaccines, it's more for the protective effect and administered to otherwise healthy people. And there's also an inevitable risk of the possibility, there's an inevitable risk of serious adverse events, such as intussusception of an infant following vaccination, an anaphylactic reaction, things that are likely to happen and are not a consequence of the design or manufacture of the vaccine. And so the question then is, how do you address that reality? Well, for the companies, as has been indicated, they want to be able to sell into markets where they have a very good handle on the potential risks, commercial risks in terms of, potential sales and profits and all that kind of good stuff, but then also potential risks associated with people being injured by the vaccines. And basically there are, and this Sam, I was reading one of the articles that you published on this, actually before the COVID-19 outbreak, but there are three approaches that could be taken to address potential risks. One is to just leave it entirely in the hands of the patient, to say, if you get a vaccine, then it's up to you to deal with, what might happen in the event of serious adverse events. The other would be, if a patient is, or a recipient of a vaccine is injured, they could take legal action against the manufacturer, sue them for product liability, for example, to get compensation. And then the last would be what we're talking about here, would be the publicly supported systems for compensation, especially the no-fault compensation mechanisms, or some combination of the three. And I'll talk about that in just a little bit. Sort of historically, these kinds of systems for no-fault compensation and ways in which the structure can be done such that it meets the needs of industry, the patients, the governments involved. The first one that I'm aware of was in 1961 in Germany, as a consequence of a Supreme Court ruling there that required compensation for people that are injured through a compulsory smallpox vaccination. And this gave rise to concern of industry because they were manufacturing this vaccine. And again, even if it, it was inevitable that there was going to be some injuries that arise as a consequence of taking the vaccine, even if it's properly designed and manufactured. And so, there was the concern of the companies that they were going to be subject to multiple lawsuits. There were concerns of the country, Germany, and other countries after as well, that as a consequence of these kind of undefined scope of potential liability that the companies may decide they just don't want to, play in those markets or participate in developing vaccines or bringing vaccines to market in certain countries where they don't feel they've got a good handle on potential liability. This was, followed up with actions taken in the U.S. in the 1970s, the 1980s. There were, some cases, such as in Germany, that arose where there were injuries that were raised, and the same kind of concerns came up of companies maybe not being willing to manufacture and distribute vaccines, and also the potential of lawsuits, being filed, the difficulties that both, the parents of kids that wanted to get certain vaccines, or the governments that wanted to put in place vaccination campaigns wouldn't be able to do so because of a lack of vaccines as a consequence of this liability situation. So in the U.S., actually a series of laws were put into place for childhood vaccines, vaccines generally, and then also in the event of pandemics. And at its core, in the U.S. anyway, it provided for a limited liability, which I think others on this workshop, or in this workshop, have discussed about. Limited immunity in the sense that, by law, you would not be able to bring legal action against a company because of side effects or serious adverse effects of a vaccine, that unless the side effects were unavoidable, and if the side effects were unavoidable and the vaccine was properly prepared and labeled. So in other words, the limited immunity would not apply in the event that a vaccine was improperly prepared, improperly labeled, improperly produced, and so on. So it was the fault of the company that gave rise to the injury. The surveys that I've seen, kind of looking at it from, starting, as I indicated, from perhaps a developed country perspective with Germany, the US, and then other countries following, there's now somewhere around 25 countries that have no-fault compensation systems in the event of a vaccine, causing an injury. And perhaps I should say, just parenthetically, is that when we talk about no-fault compensation mechanisms, it means that the individual that's injured doesn't have the burden of showing that the vaccine was produced through negligence, or that there was a direct cause, prove the causation as between the administration of the vaccine and the injury. But rather there has to be some either contemporaneous administration of the vaccine and then the injury, or some basic proof of a nexus between the fact that you received a vaccine and that you then suffered an injury. The COVAX mechanism, this is one of the examples, I suppose, of and there were others actually before this as well. When you think about the Ebola outbreaks in West Africa in 2014, 2016, which I can say just parenthetically was the primary impetus for the development of CEPI, where I used to work, an organization to fund the development of vaccines against infectious diseases, especially those on the World Health Organization's blueprint list. But we had, in the context of the response to the COVID-19 pandemic, there were efforts not only to develop vaccines, and we were involved in those, but then also look at, once the vaccines were developed, how then they were going to be manufactured and distributed on a global basis. And lots of discussions about geographic scope of manufacturing capability and capacity, intellectual property and IP licensing. But then also this issue of potential liability came up early and often, and with a fair degree of urgency. And in addition to the usual issues that that companies would raise about not wanting to be subject to a myriad of lawsuits, not wanting to have a great deal of uncertainty about the potential commercial risk if they were to go into a market. In addition, these vaccines, as you know, were approved, at least initially, to be available to markets on an emergency basis. And so it wasn't a full regulatory approval, but rather it was one that was done based upon the information that was developed, sufficient to show that the vaccines were safe and effective, but not having gone through the entire process for full regulatory approval. And then, there was, in addition, the speed at which the vaccines were being developed, which was unprecedented. To bring a vaccine to market within a year. And nowadays the target is 100 days from the identification of a new pathogen to having a vaccine. So speed has always been the essence, will continue to be a focus of work. So the speed, but then also in some instances, like with the mRNA vaccines developed, by BioNTech and by other companies, that it was a new technology, new platform that was the basis then for those vaccines. So it introduced additional elements of uncertainty, and the companies raised those concerns. Now, on the sort of countervailing side, in terms of what could or should be done, there were others obviously that were very active in this debate. So not just the companies, but those including in the international sector, including those that were part of the COVAX mechanism, that is with CEPI and the WHO and UNICEF and Gavi. They had a particular focus on wanting to bring these vaccines to market for the benefit of the countries that are going to be receiving and administering them, and more importantly, for the benefit of the people that will be receiving them. And there was a desire not only to see to it that those vaccines were developed and manufactured and distributed, but that they were equitably accessible on a global basis, and that the access wouldn't be done to the disadvantage of the people that are receiving the vaccines. That is excluding potential liability, let's say, entirely, but then not providing some degree of protection for the people that are receiving these vaccines, again, that had been made available on an emergency basis, have been developed rapidly and on new platforms. So there was a desire to address the concerns of the companies. There was a desire to address the concerns of the countries and the people involved as well. And so, there was set up in parallel to this mechanism that will provide a degree of protection for the companies, to one that also included a compensation mechanism that would compensate people in the event that that they are injured as a consequence of taking a vaccine. I'd be happy to. I know that I have just a little bit of time left here, about 5 minutes actually. I'm not going to go into a lot of detail in terms of how the compensation mechanism worked, in the sense of how much of a compensation, how often compensations were paid, and that type of thing. But I can during the Q&As if people want to focus on that. What I wanted to say about the mechanism that was set up is twofold. One is that the scope of coverage endpoint, or scope of coverage, the scope of coverage endpoint for the COVAX mechanism was 24 months following the date on which a vaccine was first put into circulation. Now, this is an important component, if not innovation, of this mechanism. The purpose of which was to address the point, that it may be possible for the companies to insure against the potential for injuries as a consequence of the administration of a vaccine, and addressing that potential risk could be done through self-insurance or getting insurance from the commercial sector. Now, again, going back to where we were at the beginning of the outbreak, there was a lot of uncertainty about, whether, vaccines would be developed within a timely fashion, and then uncertainty as a consequence of, these new platforms that were being used, the speed of development, the fact that the vaccine was available under emergency authorization. And so, while there was a need, to address as many of those uncertainties as possible, in this kind of compensation mechanism, the feeling was, that by a certain period of time, some of the uncertainties would be resolved, such that the companies would be in a position to seek and obtain their own insurance. Again, insurance, either self-insurance or insurance, from companies. And with respect to, again, going back to the notion of the no-fault compensation in the COVAX mechanism, the inquiry, was whether the vaccine was the most probable cause of the injury. Most likely cause based on the balance of probabilities that a vaccine or its administration resulted in a claimed injury. So again, there wasn't a need to prove a technical correspondence between the vaccine or the way that it was administered and the injury. It was just sufficient, that there was a balance of the probabilities that was shown that indeed that's what gave rise to the injury. There was also a need, to have a publicity campaign for the COVAX no-fault compensation mechanism, so that countries, people that were administering the vaccines, hospitals and so on, would be aware of it in the event that injuries occur, and what they would have to do in order for a particular patient to seek compensation. The other piece, I'm going to talk about this and then one other point, and then close, my presentation here. But another piece of the mechanism that was set up in COVAX, and this is something that has been discussed by some of the other folks on this panel, is indemnification. And in the case of COVAX, the indemnification was for the countries that within which the vaccines are going to be administering. The countries within which the vaccines are going to be administered would agree that in the event that there was a legal action that was taken against a company for liability, again, this would not be a no-fault context, but rather it would be an action taken in court by someone who is injured to say that because of negligence or some other cause, the vaccine was unsafe, caused the adverse event, and the compensation should be paid. And so what the companies required was that they would be indemnified against the possibility of those kinds of action being taken and successful. And what that would mean is that the country would agree to pay, whatever the judgment was by the court for that liability. Now, the theory, and it's actually a theory that works in practice for COVAX, it's worked in practice in other contexts, was that you would have the possibility of legal action being taken. You would require indemnification with the expectation that the no-fault compensation mechanism would be sufficiently attractive that would be the route that most people that are injured would take, rather than taking legal action against the company in the national courts, because that takes time, takes money, it's uncertain, and so forth. But with the no-fault compensation mechanism, it's more sure, it's more certain, it can be processed quite quickly to provide compensation. So I'm laying out, these elements here with the indemnification, the no-fault compensation mechanism, the scope of coverage issue that I mentioned, 24 months, then the companies would have to seek, their own insurance mechanism. I'm laying these out just to say that, there are a number of elements that necessarily one has to go through in thinking in a particular context as to what the best way forward is. And, there's a number of examples across the world as to how these things can be structured, including no-fault compensation mechanisms where it's a government that's paying for it, or no-fault compensation mechanisms, like in Sweden, for example, where it's an insurance mechanism, the premiums of which are paid by the companies. There's a number of different options that could be looked at, but there's 6 or 7 different elements that have to be addressed in setting up such a system. Administration and funding, again, whether the funding is going to be, by industry, by the insurance sector, by by the companies that are manufacturing or otherwise. Eligibility for compensation. How is it that, you are making a determination that a particular injury is as a consequence of the administration of the vaccine? Process for decision making, these mechanisms, they have to be administered. You have a standard of proof as to whether or not, somebody has or has not been injured. A variety of elements of compensation, that could be for, it could be, the injury itself. It could be loss of time at work, for example, or it could be, things that are a temporary injury or permanent injury. So there's a number of different elements of compensation that have to be looked at. And then this issue of litigation, whether litigation will be possible, and if so, under what circumstances, and will it be limited, and so forth. Now I'm just kind of laying that out, just to indicate sort of not so much the complexity of this issue, but rather that there's a number of different considerations that have to be fully addressed in setting up a mechanism to address potential liability, including a responsive and no-fault compensation mechanism. And the other is to say that these elements will vary depending upon whether this is a national undertaking or something that is intended to be on a global basis, like the COVAX mechanism. So let me stop there and hand it back over to Sam, and look forward to the Q&A. Thank you.
Thanks so much, Dick. So I am the next speaker, and I'm going to be primarily addressing the structure of draft Article 15. And in many ways, the previous speakers have sort of laid out in a lot of detail what it is that Article 15 aims to accomplish. So I'll sort of go over the structure of Article 15, identify a couple of ambiguities within the text, but then ultimately reinforce what its primary aim is. And then we can start to talk a little bit more about sort of general questions and thoughts on all of the presentations. So Article 15 is divided into 3 parts. One essentially articulates that those states who plan on joining the accord should set out national strategies to address liability and risk management. Part 2 vests the conference of the parties, the proposed conference of the parties, with the obligation to establish a no-fault compensation mechanism within 2 years. And then Part 3 essentially provides a set of limitations, or how the limited scope of Article 15 should function as implementation unfolds. There are sort of important differences between draft Article 15 and what was proposed over the summer by the INB Bureau. There's sort of a little bit less specificity in some parts and a little bit more specificity in others. And I'll talk a little bit about sort of through public proclamations, sort of some of the I wouldn't necessarily call them disagreements, but sort of different ways of thinking about each of those provisions. So, paragraph 1 of draft Article 15 obligates states parties to adopt national policy frameworks to address liability and risk management. And they specify many of the approaches that John, Chanel, Sharmila, Dick all articulated, right? So national governments, they should develop model contractual provisions. They should provide and start to develop national guidelines, including authorizing legislation. They should also, and this is, I think, important for this audience especially, they should start to build the capacity of lawyers who will be negotiating these agreements at the time that it's necessary. So this idea of contractual support or negotiating capacity is specified in paragraph 1 of draft Article 15. Again, through some public proclamations of delegations and national governments, there is some so there's some modification of some of those terms. So, for example, some governments want paragraph 1 entirely cabined by national frameworks that already exist. So if you have an approach to liability risk management at the national level, and Dick mentioned sort of 25 governments that have adopted something like that national approach, then they would essentially sort of operate under a principle of complementarity, right? And that would fulfill their obligation under paragraph 1. Paragraph 1 also specifies that it applies to novel vaccines. Novelty is not defined otherwise in the draft text. It is an important point of ambiguity. It might be worth a discussion in this forum, right? So the mRNA platform vaccines, Pfizer, Moderna, I don't think anybody would contest that those are novel in a kind of material and important way, right? As is the platform for AstraZeneca's vaccine, a viral vector platform. But I don't think that we should think of novelty as being limited to platform in that sense. So, for example, H1N1, 2009, 2010, a novel vaccine, a monovalent vaccine that was specific to the pandemic strain was developed. I think there's certainly a plausible argument that that would also be considered novel. And it's important. It's an important point being negotiated by the parties, I'm certain. And that's especially important as we move to paragraph 2, which doesn't use the word novel. It uses the word pandemic vaccine. Pandemic is defined in the definitions of the draft treaty. It's quite a long definition, but paragraph 2 vests the COP or charges the COP with developing a mechanism for no-fault compensation using existing models. And that mechanism is further repeated in Article 20, which broadly outlines the authority of the COP to develop financial mechanisms for support of the treaty regime in general. So at least as a threshold matter, the approach of the treaty text is that no-fault compensation will be one of the operating mandates of the COP. Again, there is sort of the position of some governments that if they have functioning national frameworks, that would effectively exempt them from a mechanism that might be adopted at the COP level. There isn't really further detail about how that mechanism would work as it's developed at the international level. Paragraph 2 also authorizes those mechanisms to work in a regional way. It's fairly broad in its scope, in its expectations. I don't know for sure, but I suspect it's modeled after the WHO approach within COVAX and those receiving COVAX brokered vaccines. But there's certainly publicly pronounced positions by governments that might not be a function of the COP in the ultimate treaty text. And finally, paragraph 3 addresses broadly the limited nature of those contractual provisions, promises of indemnity, and temporal limits of this approach, right? Managing liability risk in a way that uses either immunity, as John and Dick have articulated it, or indemnity, again, as I think Dick explored in probably a little bit more detail. Now, the Bureau text released this summer had a specific time frame, a time frame of 2 years that isn't in the current draft text. The draft text specifies that they should be essentially exceptional, right? This shouldn't be a broad waiver of liability for manufacturers. And it also specifies that they should be quote unquote time bound. So there might be a kind of idea that 2 years would be an expected time bound limit, but that isn't specified. It could be 1 year, it could be 3 years. It could be other kinds of limitations that the parties specify. Again, all of those 3 paragraphs, the ultimate thrust of the treaty provision is that we are trying to shorten the amount of time it takes for the manufactured medical interventions to reach the populations that need them. And notwithstanding some of the language which is lawyerly and does adopt these terms that might not be widely used or really appear in national legislation, that is their ultimate aim. And our position is that it is consistent with what the Global Health Security Agenda Legal Preparedness Action Package has advocated in terms of preparedness, even if there are certain details that would need to be sort of resolved and worked out. So I'll go ahead and leave it there because I know we want to leave plenty of time for questions from the audience. I believe we've already received a few in advance of the session, and Kat has put the draft text of Article 15 into the chat, which might help. So with that, I'm going to go ahead and sort of open the floor to questions, and I'll probably ask Kat's assistance in sort of prioritizing some of those questions to address initially, and maybe even the speaker to whom might be best positioned to initially respond.
Sam, it looks like we have Kriti and then one in the chat as well.
Yeah, go ahead, Kriti, and then Kat, I might go to the question posed about public versus private sector burden of responsibility.
Okay.
Good. Kriti, go ahead.
Hi, good morning, Sam. I wanted to ask a question regarding the para 3 of this article, where they're saying that they're proposing a no-fault compensation mechanism. But then how do you think this is going to work? Like, if there is, is this going to be no-fault compensation that is going to be negotiated at a state, at a national level with pharmaceutical companies? And then they also say something about that there has to be, that the COP may have to develop like regional and international strategies. So how is this going to look like in a real time model? Who's going to be liable?
Well, and actually, I may ask Dick to weigh in a little bit. Again, it isn't specified, but I suspect it is modeled on COVAX, where there is a direct interface by the available to the injured party to submit the claim. And so, and at least it was thought on the front end that claim would be drawn on from WHO resources in an agreement with Chubb, which is a subsidiary. But I believe at least initially there was idea that the manufacturers would contribute to that available fund for resolution. But I think Dick can provide a little bit more detail.
Yeah, for COVAX, the funding was provided by basically the funding mechanism for COVAX itself, from the member states, that were standing up, the COVAX mechanism, but then also the no-fault compensation is an integral part of that. It wasn't paid for by the companies. That's not to say that it couldn't be or shouldn't be. It's just, the way things were done. Yeah, and I think Kriti makes it's a really good question actually in this context to to try and determine how or at what level, let's say at what level in terms of government responsibility this issue of potential liability should be addressed. Should it be on a country by country basis? Should there be some a regional mechanism? The multilateral mechanism of COVAX is an example of how that could be done. That obviously was for the benefit of the 92 AMC countries as defined by Gavi. So it was not all countries of the world, but those low and middle income countries that required that degree of additional support. Um, and ideally, you would set up mechanisms, such that you would address this issue as broadly as possible, and not have to do it country by country or even on a regional basis. That said, I think that's one of the devils in the detail in terms of how to set this up would be, whether you can, which I think is the aspiration for the pandemic treaty, would be to deal with these issues on a global basis. But it may be that there has to be some built-in mechanism whereby some things will be on a more bespoke basis on a the country by country level or regional, just because of differences of legal history and situation with respect to local manufacturer of vaccines and so on. Over.
We have a second or a question in the chat. Why is the primary focus of this article on novel vaccines? And it's a fair question. And I think it goes to this idea of definition for sure. It's entirely possible that the necessary medical intervention in a future pandemic might be a small molecule intervention and not a vaccine, or even as those interventions develop, right, monoclonal antibodies aren't sort of as a regulatory matter regarded as the same as vaccines. It's an entirely fair question. If somebody is more familiar with the development of that text, I feel free to yield, but I suspect it goes to once you start trying to define something like a medical product or a diagnostic in an international instrument, it raises national problems of definition and approach. And over the last several public health emergencies of international concern, so COVID, Ebola, H1N1, the intervention ended up being a vaccine, but it's a quite a fair question. So I invite any other panelists to address it. Dick, did you have a thought?
Yeah, just say one thing real quick is this goes back to what I was talking about earlier in the context of setting up the COVAX system, and again that was just for vaccines, so potential liability for vaccines, and that is a difficulty in getting insurance. It's easier to get insurance for manufacturers of therapeutics and diagnostics, more so than biologics or vaccines and so on, because of some scientific uncertainties associated with those technologies. I'm just saying that because I think that one reason to perhaps have a particular focus on vaccines or novel vaccines for liability purposes is because of that. Again, the last thing I'd say, it goes back to something I said earlier in the context of how this issue was addressed for COVAX, and one element of it was to have a time limit during which the indemnification obligation would subsist, as well as the availability of no-fault compensation. And that time limit was intended to reflect the possibility that in a certain period of time, full regulatory approval, full understanding of the risks of a vaccine could be achieved, and the companies would be able to resort to their own resources or the private sector insurance industry to get coverage for potential liability. And I think the same kind of considerations that apply there in setting that kind of a time limit also apply in analyzing whether it's no fault compensation is needed at all in the case of certain interventions, in particular therapeutics and diagnostics. Over.
John, I don't know if you wanted to add a thought.
No, I agreed with what you and Dick said. The only thing I would say is if people in the audience are sitting from the perspective of a national government, you know, there will be ultimately some boundary to the products that are covered by the pandemic accord. And so as you're analyzing this, it may be useful, as Dick said, to think of it from the full range of products that the country is interested in, and where does, you know, how are you handling therapeutics, other kinds of products, and understand what how the boundary between how your nation handles the set of issues for a whole range of products and where this carve out is. Just maybe a way to look at this to understand what your interests are in this space.
Okay. There are no other. It's an entirely fair and good question. I think that is the best that this panel can get to you, short of somebody from the INB speaking to the issue itself. There aren't additional questions in the chat, so I want to start to pull in some of the questions we received in advance. The first of which was, you know, who should be liable, the government or the private sector? And I think it's fair to say that the approach of Article 15, at least, does not prejudge the answer to that question. And Dick, I think, did a good job of articulating different approaches and regimes that national governments have taken to that issue. So, for example, in the United States, for routine immunizations, you know, there's a 75-cent levy on each dose, and that levy ends up funding our compensation fund, the United States compensation fund for people who suffer rare serious adverse reactions that are on a CDC developed table of injuries. So it doesn't. So, for example, in that system, private manufacturers contribute some. The government sets up the machinery for adjudication, and that is one approach. There could also be an approach where insurers are primarily the ones who sort of drive the system, contribute to it. Management in New Zealand, and if there are representatives from those countries on the line, I feel free for them to correct me or just articulate sort of everything is managed under a comprehensive accident system. So in some ways, sort of, you know, vehicle accidents and immunization injuries are treated the same. And so that is, and it makes sense to, depending on national approach, to have a system that speaks to national priorities and national preferences with respect to whether or not private sector actors are better able to shoulder liability or public sector governmental ones. The most important thing is that those systems be in place so that you're not negotiating in real time in emergency circumstances what those details will be. But I think everybody who has spoken has seen a piece of that issue and could probably speak to it. Okay. Does anybody else want to weigh in?
Sam, I think you summarized it well. I also, again, it's kind of like my last comment. I think the most important thing, at least from where I sit, is for countries to address this issue before you get in the emergency, which was your last point. And that means you do have to think about how an emergency system fits in with the rest of your countries. Take very different approaches to, as you said, everything from automobile accidents to other kinds of harm that may be caused by medical products. So like, now is the time to think about how an emergency corresponds to the systems you have in place for other situations. Maybe it's completely separate, and the issue of financing obviously is fundamentally a political decision in each country about where you're going to raise. I mean, government revenues come from some taxpayers, so you just have to figure out what's the politics, frankly, the political economy of figuring out where the revenue source is going to come from. The risk doesn't go away.
We have another good question in the chat, one that I think all of us, at least at an academic and research and scholarly level, have really struggled with, which is since the determination of causation ends up being a key inquiry for purposes of compensation, who is it that determines whether there's a causal relationship? That isn't specified in the draft treaty text. Different countries, again, take different approaches to that issue. So, for example, as I mentioned, in the United States, there is essentially a table of known or suspected injuries that is developed by public health experts, and if the injury corresponds to an injury in that table, then compensation issues. Under COVID, that inquiry has become a lot more flexible, right? So that there just needs to be an association between the time of administration of a vaccine and then when a corresponding adverse reaction results. There isn't in the COVAX system, that determination is made internally. I don't believe that WHO or Chubb have shared their criteria. We do know a series of rare adverse reactions for viral vector vaccines. We know those reactions for mRNA vaccines, or at least we know them so far. But that mechanism isn't specified. But again, I want to contextualize that with it is much better to struggle with the causation issue in the rare adverse event circumstance than to try to figure that out in real time. So it's more important that standard be developed in advance than that we get it perfectly right, which is probably impossible. But again, sort of I think Dick and John and Sharmila and Chanel may be closer to thinking about that issue. But in many ways, it's a kind of core and fundamental problem with thinking about no-fault compensation. Any other thoughts on that? Again, the very.
I think Dick has his hand.
Oh, sorry. Go ahead, Dick.
Yeah, I was going to say just real quick with respect to not just the COVAX mechanism, but things like that is, and I'm not sure whether and how this issue of the decision making, both what is the technical basis for the decision and who makes the decision as to whether or not a given claim is receivable and whether or not there's going to be compensation paid. I think having something fairly general, like in COVAX, and then the details to be filled out later, as the administrator, whoever's making the decision, has some experience under their belt in terms of how those kinds of decisions will be made in that context, I think is very important. And again, I don't know in the treaty language, the extent to which it currently does, but I think it should, reflect the fact that there are going to be, a need to have some differences and some specificity depending upon how the no-fault compensation system is set up. Again, whether it's national, regional, global, and so on, and who the decision maker is. I don't know that you'd be able to have, one single detailed set of instructions that would be applicable across the board to all of these types of no-fault compensation systems that exist now and that may exist going forward.
Sam, could I just build on that?
For sure.
Dick, I totally agree with everything Dick said. The only thing I'd say, just thinking of it maybe from one country's experience, the United States, um, I agree with Dick. I think you want to keep it general. You want to have an administrative structure that has some experience. The sort of the other considerations that may make you want to balance it is speed may be important in terms of not only just sort of providing compensation to people who have suffered an injury that meet whatever criteria you set. That's important, obviously, for the person and their family. But the other thing is, it may also be important for your public health response to have a system that is seen as responsive on a timely basis. And the second concept, and this has come up in the concept of childhood vaccines in the United States, is just at some point, you also want to have a system that can explain. Dick mentioned earlier about the publicity, about the availability of the mechanism. As claims are adjudicated and found, they'll be, at least in the U.S. experience, it's maybe different in other countries, I fully appreciate. But there has been public demand for clarity as to how decisions are made and over time, especially just if there's a perception that the system isn't as fair as it could be. So that's just something to build in. It's a counterweight to flexibility is expecting transparency, and you may value speed as well. So just as you strike the balance.
We have a comment in the chat that has to go to this idea of negotiating or procurement or legal capacity. We appreciate the comment. We share it. So one of the priorities of the legal preparedness action package is to develop some of those capacity assistance tools over the course of 2024, including if that provision ends up being in the final text and agreed upon text. Hopefully standing by to support countries. And the question of procurement is a good one that I should mention with even more specificity. So lots of governments, and in fact maybe most governments, have rules around what is required for procurement by public sector entities, state-owned entities. And one of the legal issues that arose over the course of COVID-19 was having a mechanism to essentially waive those rules, right? Because you are supposed to open up a process for open bidding, and there's supposed to be a scoring process on the bid, all of which takes an enormous amount of time. So, for example, laws that allow the normal public procurement process to be circumvented for United Nations procured products, or products procured in the course of an emergency, or a legal step that every government could take at this point. We received a question in advance about the link between, and I assume this question is about the liability risk management, the link between liability risk management and the negotiating process in Geneva. I mean, that's a question that would be really specific either to the INB Bureau, or if there are representatives from missions who feel authorized to speak. I get the sense that its relationship to the negotiation in Geneva really just has to do with preparedness, shortening the amount of time between when interventions, vaccines, therapeutics are manufactured and available and when they can actually reach populations. Part of the reason we wanted to host this webinar is because it has been raised as sort of protective, perhaps unjustifiably protective, of industries located in North America and Europe and Japan and Canada and Australia, essentially being protective of their interests. And I think that we understand why that perspective may obtain, But the reality is that the manufacturing capacity for vaccines already is, and in the near future will be, much more widely distributed, right? So these provisions would be just as protective of South African manufacturers and Indian manufacturers and Tunisian manufacturers and Thai manufacturers as sort of North American, European, or Japanese-based manufacturers. So even though I think in the current circumstance, I think I could see that idea that it's overly protective. I don't think that's its ultimate rationale. And I to the extent that there's a quote unquote negotiation in Geneva, I think that's it. Is it a giveaway in some sense, or is it really justified on a public health basis? Our position is that it is the latter, but entirely understand the sentiment for the former, and invite other questions or thoughts on that issue. We have a question in the chat. Have there been any problems wherein compensation without evidence of causation leads to misperception that the vaccines are riskier than they actually are? It is I'll answer initially because it's such a critical question that so many of us have spent time exploring. That is even the communication around no-fault compensation entails risks, right? And these risks were made salient in the course of COVID-19, and have been and actually are in the world of immunization generally. If you have a system for compensation for potential side effects, are you implicitly saying that you do not have trust in your regulatory apparatus to ensure safety, probably more so than efficacy? Or does the compensation system simply speak to that very first reality and principle that John articulated, which is there simply are no medical interventions that do not carry risk of adverse event, and we are simply making sure that a small subpopulation is not left bearing significant financial loss so the rest of the community can enjoy protection from an infectious disease threat. There is, so far as I know, no good survey-based data to answer that question. It absolutely is a risk, right? What we do have are anecdotes and episodes where immunization campaigns were associated with adverse events when in fact there wasn't a causal connection. So it is certainly a risk. Again, I think that the position of but speaking certainly for myself, but I think for the broader ethos of the legal preparedness action package is that even if that misperception obtains, we have still saved far more lives by shortening the time in which the interventions are made available to populations. But invite the thoughts of others. John, did you have a?
The only thing, Sam, I think you hit it right on the head. The only thing I would say is if you're planning a public you want messaging around any no-fault compensation system needs to be carefully done, and there's no perfect way to do it. And you're exactly right that there is some risk, and experience suggests that their adverse events can contribute to problems. The other thing I would say is the flip side is you have to think through if you don't have a compensation system in place and you have events, how do you manage that? You're going to go into, I think, unless the science changes, you're going to go into one of these with some level of uncertainty that you cannot resolve entirely in advance. And as a result, you have to think of the scenario, where do you want to be? Obviously, how do you message something so that you minimize any confusion and you maximize support for the campaign, but you also have to prepare for the plan B, which is what if something doesn't go well, and what if some issue does, some event is arguably blown out of proportion or not? What do you want the response to be, and are you comfortable? And I think not having a mechanism to compensate people for harm might just compound and extend the story, as opposed to be a fair way to address a sad, tragic situation.
Go ahead, Dick.
Yeah, thanks, Sam, and I apologize for weighing in so often here. But one thing I wanted to say, and this goes back to something that you had said earlier, Sam, and then John just now, and that is what I laid out, and I think others on this call or this seminar have laid out is where we are, and looking back, historically, where we've come from in respect of this issue. And then looking at the treaty, we're looking at sort of, the future state of where we, could be, should we choose to go in that direction. And the specific point that I wanted to make is not just to observe, that we have a history here and that things are changing, but rather to say that, as Sam was indicated, I think that the whole industry is going through fundamental evolution with respect to where vaccines are manufactured, including increasingly in low and middle income countries, which does affect how one goes about thinking about these issues. And one way to talk about that is to say that while there may be some of these newly emerging countries that are getting involved in manufacture and distribution on a global basis in a big way, have a different risk tolerance than, let's say, the companies from Europe and the United States, where these ideas around no-fault compensation, indemnification, limited immunity, where they arose. And I think we have both an opportunity as well as an obligation to look at that changing context in terms of the global manufacture, distribution, utilization of vaccines, and ask those questions as to whether we want to take advantage of what we learned to date, particularly through activities in certain geographies, or whether there's cause now for us to rethink some of that. And by rethinking, I don't mean throw it out. I mean, certainly when we were working on the no-fault compensation mechanism and indemnification mechanism for COVAX, we looked to the past in terms of how things have been done. We listened to, what the players in that debate both, wanted, and sort of the philosophy behind what it is that they wanted, and came up with an approach that was, let's say, less than what some in industry would want, but nonetheless was effective for the COVAX context. And so, just we have to recognize that the global environment, or the global mechanisms for manufacture and distribution of vaccines are evolving, and I would say rapidly evolving, and that needs to be part of the inquiry in terms of how we rely on examples from the past, and what we again want to see in terms of how these issues are dealt with going forward. Over.
Okay. We have another advanced question. The question is, what is the legal basis for the funding mechanism articulated in Article 15 and ultimately Article 20? I don't know that I have a better answer, just than that, sort of in the treaty formation process, states parties are free to obligate themselves financially or not, as the agreement compels. So in the current draft text, there is envisioned a funded no-fault liability mechanism, at least initiated by the COP, if not administered by it. And that is the legal basis. It's just an international commitment to do so. And that kind of commitment exists in a number of treaty regimes. But if there's additional follow-up, or anybody else wants to weigh in on that question, I certainly invite them to do so. Or if I have misinterpreted it. Okay, and then the final advanced question has to do with cyber liability and managing sort of cyber liability, which I take to mean sort of information technology and computer security. And that is, it's a very good question. It's an important one in general in the area of pandemic preparedness. It actually isn't the risk. It isn't the type of risk envisioned by Article 15. It isn't the type of risk envisioned in a liability and risk management context here. Elsewhere in the treaty, there are concerns about privacy integrity, or at least privacy integrity is mentioned, right? Because a great deal of the proposed text has to do with things like clinical trial preparedness and sharing data across borders. But I don't think cybersecurity itself is one of the liability and risk management issues covered by Article 15. But covered by Article 15 or not, I invite others to sort of, if they have any thoughts on cybersecurity. Okay, so that is the conclusion of the questions. It's also very close to the expected end of the Q&A, which is something like miraculous. And so I want to again repeat thanks to the speakers and to everyone who and Kat has always read my mind. If you have questions that you would like to pose, you can email the GHSA Legal Preparedness Action Package Secretariat. We encourage you to do so. And if there are no other thoughts, we can go ahead and sign off. I should also mention that this session has been recorded, and I don't think we have an immediate forum for sharing. But if you're interested in the recording, contact the secretariat. All right. Again, many thanks to our speakers and our organizers. Kat, just to make sure I didn't forget anything.
Nope, we're all good. We'll probably send the email out to everybody or the recording out to everybody who is registered when we get it uploaded to YouTube. But thanks everyone for your participation.
All right. Thank you all so much.
Thank you.
Thanks, everybody.